moderator for this session. Before we begin, I would like to remind our spectators that their microphones and cameras should remain off at all times. For judges and participants, please keep your cameras on and your microphones on mute when you're not speaking. All present. Session 2 of the Walker-Moot Supreme Court is now in session in the Dr. S. Glazer courtroom. It is with great honor and privilege that I present Justice Lindsay Charles from McLeish-Orlando, Justice Nick Todorovic from McLeish-Orlando, Justice Brianna Young from Torkin, Maines, and Justice David Miller, Doctor of Oral Surgery, presiding. Justices of the panel, I present to you, speaking on behalf of the appellant, Mrs. Armstrong, in today's matter before the court, Hussein Kassam and Adam Walji, and speaking on behalf of the respondent, Dr. Ward, Nishani Baskarajah, and Suzanne DeLuca. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and the respondent's counsel will have 30 minutes each in total, 15 minutes for each counsel member, to present their arguments to this court, including answering questions from the bench. The appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there's 5 minutes left per signal, per speaker, like this. Can everyone see that? Excellent. Appellants, will you be using your 3-minute rebuttal? Yes, perfect, thank you. The court now invites counsel for the appellants to begin.
Thank you. Good morning, honorable justices. My name is Adam Walji. My colleague, Mr. Kassam, and I are representing the appellant, Ms. Armstrong, in the present appeal. Following a brief overview of the facts, I will discuss that in accordance with the common law, the trial judge did not err in his formulation of the standard of care. I will then proceed to describing how the trial judge did not err in determining what factually happened when conducting the standard of care analysis. Mr. Kassam will then address the question of whether the plaintiff had a duty to rule out non-negligent causes of the injury, and will end with a discussion on the appropriate standard of review that respectfully should have been conducted by the majority of the Court of Appeal for Ontario. On February 5th, 2010, the respondent, Dr. Ward, performed a laparoscopic colectomy on Ms. Armstrong. During this operation, he used a ligature device, which uses electric current to separate and seal tissues. It is important to note that the thermal energy emitted by the ligature device can cause damage to the surrounding tissue in close proximity. And at trial, it was concluded that close proximity is within 2 millimeters of the ureter. Following the surgery, Ms. Armstrong experienced a blockage in her left ureter, and the damage caused was so significant that it resulted in her kidney having to be removed. At trial, the trial judge ruled in favor of Ms. Armstrong, concluding that Dr. Ward did not meet the standard of care. 4 expert witnesses and Dr. Ward himself testified at trial. There was consensus that the standard of care consisted of identifying, protecting, and avoiding direct contact or close proximity to the ureter when using the ligature device. The majority of the Court of Appeal for Ontario overturned this decision, with Justice Van Rensburg dissenting. The majority concluded that the standard of care that had been established by the trial judge had been met by Dr. Ward. Justice Van Rensburg, on the other hand, concluded that the trial judge's decision was fully supported by the evidence at trial. And it is our submission that the dissenting reasons of Justice Van Rensburg were correct, and we respectfully ask this court to adopt her reasons and conclusion. The questions in issue in the present case are as follows. Did the trial judge err in his formulation and application of the standard of care, particularly with regards to the need to keep at least 2 millimeters of distance away from the ureter? Did the trial judge err by using factual causation as evidence when formulating the standard of care? Does the plaintiff have the duty to rule out non-negligent causes of the injury? And finally, did the majority of the Ontario Court of Appeal err in applying a correctness standard of review? And if so, what was the appropriate standard of review it ought to have applied? Addressing the first question in issue, the formulation and application of the standard of care, if you wish to follow in our factum, our arguments begin at paragraph 25 on page 9. It is our submission that the appropriate standard of care in the present situation includes identifying, protecting, and staying more than 2 millimeters away from the ureter when using the ligature device. And the common law has stated that in medical negligence cases, the medical practitioner must bring a reasonable degree of skill, knowledge, and care to the task. This practitioner is expected to exercise the same level of skill, knowledge, and care as would a normal, prudent practitioner with the same level of experience and standing. Referring to paragraph 28 of our factum, it has also been held that when it comes to the evaluation of a medical practitioner, judges and juries alone are not in a position to compare the conduct of the practitioner to that of a reasonable medical practitioner. Rather, expert evidence is required with regards to whether the practitioner in question acted or omitted to act in accordance with the approved practice. And I highlight that this evidence required is expert evidence. And in the present case, the trial judge considered and relied upon the testimony of the expert witnesses when formulating the standard of care. There was no results-oriented approach or standard of perfection in the current case. As mentioned by Justice Van Rensburg, the evidence at trial fully supported the trial judge's formulation of the standard of care. Dr. Bernstein, one of the expert witnesses presented to the court by Ms. Armstrong, agreed that the appropriate standard of care during a laparoscopic procedure is to identify the ureter, then push the ureter towards the patient's head, away from the colonic mesentery, and finally, when using the ligature device, to stay away from the ureter. Referring to paragraph 32 of our factum, Dr. Hagen, who I might add was an expert witness presented to the trial court by Dr. Ward, also agreed that identifying and moving the ureter away from the colon, followed by, when using the ligature device, staying away from the ureter, were reasonable steps that meet the standard of care. In fact, he was specifically asked about the need to maintain that 2 millimeters of distance, and he responded by saying that staying at least 2 millimeters away from the ureter was an important step that a reasonable surgeon should take. I would also like to emphasize that Dr. Ward himself agreed that a surgeon is required to stay away from the ureter during the removal of a colon, where a ligature device is used to separate the colonic mesentery. Specifically, he stated that staying away from the ureter while using the ligature device was a step within the standard of care. Dr. Robinette, who was also an expert witness presented to the court by Dr. Ward, stated that the standard of care was to identify the ureter and stay far enough away from it. And he agreed that any use of the ligature device within 2 millimeters of the ureter was a breach of the standard of care. Now, the point of disagreement that was unusual from the appellant's perspective was that when asked to assume that Dr. Ward had come within 2 millimeters of the ureter, both Doctors Ward and Hagen refused to acknowledge that that would be a breach of the standard of care. And the reason this is so baffling is because this directly contradicted what they had established to be the standard of care. I would also like to take a moment to discuss the idea that the majority submitted and put forward with regards to the trial judge's approach being a results-oriented approach. It is our submission that the majority erred in stating that the trial judge used a results-oriented approach for two reasons. The first reason is that the goal and the result of a colectomy is to remove the colon. And the second being that throughout their testimonies, the expert witnesses agreed that keeping a safe distance from the ureter was a step. It wasn't a result. It wasn't a goal. It was a step. And it was never submitted to the expert witnesses at trial. It was never presented to them the possibility that it could be a result. Therefore, it is our conclusion that the majority erred in stating that it was a results-oriented approach. It is also our contention that the majority erred in stating that Dr. Ward had not breached the standard of care since he took the steps required to identify and protect the ureter. Respectfully, this assertion takes the trial judge's words out of context. The trial judge stated repeatedly during his reasons, that the standard of care included the final step of maintaining that distance of at least 2 millimeters from the ureter. And at paragraph 109 of his reasons, when the trial judge was stating that Dr. Ward had taken steps to identify and protect the ureter, it is our contention, and Justice Van Rensburg was in agreement, that he was describing how Dr. Ward had taken some, but not all of the steps required under this to meet the standard of care. It is our submission that Justice Van Rensburg was correct when she stated that what the trial judge meant was that Dr. Ward did not complete the final step of the standard of care, which was actually maintaining that 2 millimeters of distance.
Counsel, can I interrupt for a question?
Yes.
Thank you. I'm a little concerned that this standard we're creating is going to result in any, doctors being found overly negligent, as we're kind of creating almost a perfection standard here. It's seeming like we're kind of going down the path of, any negative outcome of a surgery may result in a doctor being found negligent. Can you just help me, see how that isn't a potential concern for us?
Yeah, and my response to that is, we submit that it is not a standard of perfection, and I say that for two reasons. The first being that the general consensus between the expert testimony, right, all agree that a step was actually to maintain the distance. And so as the common law states that, when it comes to establishing the standard of care in medical cases, the expert witnesses know best. And so the fact that there was a general consensus from expert witnesses from both sides suggests that, okay, it wouldn't be a standard of perfection, it's the standard required. The second part of my response to that is when Dr. Hagen was testifying at trial, he also mentioned that if a surgeon took the reasonable steps required, you wouldn't be anywhere near the ureter. And so given the fact that the colectomy is a relatively standard procedure and a common procedure, I wouldn't say that it would be a standard of perfection, given that combined with the general consensus of the expert testimony and the fact that when following the required steps, you wouldn't be anywhere near the ureter, I would say that would not be a standard of perfection.
Thank you, counsel.
Thank you. So I will allow our factum to discuss the remaining arguments of that first question and issue, because I do see that time is speeding by. So what we'll do is I'll move to, subject to any other questions, I'll move to the second question and issue with regards to the factual causation informing the standard of care analysis. While it is generally accepted that the trier of fact will consider causation after the standard of care analysis, there are situations where there's a need to establish the factual cause of the injury in order to determine whether the standard of care was breached. And you'll note at paragraph 43 and 44 of our factum that the standard of care analysis essentially has two parts. The first is what is the standard, and the second is whether the act or omission of the practitioner meets that standard. And in order to answer that second part, the trier of fact must comprehend what factually happened. In Marangolo and Grass, the Court of Appeal for Ontario highlighted the necessity to evaluate factual causation. And both these decisions highlight that factual causation must be considered before evaluating negligence. Furthermore, the primary inquiry in this step is to determine what the surgeon did or did not do in fact. The focus is on the act or omission of the surgeon and whether it falls beneath the standard. As stated in Kennedy, the outcome to the patient is not necessarily relevant other than determining what the surgeon did or did not do. And while it is true that the but-for test for causation cannot be addressed until the standard of care analysis is complete, Justice Van Rensburg correctly noted that Marangolo, Grass, and Kennedy all support the notion that there are situations, such as the present case, where it is necessary to determine what happened so that a conclusion can be reached as to whether the standard of care has been breached or not. And so I noticed that my time is nearing an end. So I will allow our factum to make the remaining arguments for this question and issue, and I will pass it to Mr. Kassam, who will address the final two questions in issue. Thank you.
Thank you very much, Mr. Walji. Honorable Justices, this morning I will be looking to address whether the plaintiff had a duty to rule out non-negligent clauses of the injury during trial, and we'll end with a discussion on the appropriate standard of review that respectfully should have been conducted by the majority of the Court of Appeal of Ontario. It is our submission that the trial judge did not err in excluding the possible non-negligent causes. Matters relating to negligence usually require the analysis of non-negligent causes before the trial judge to determine breach of standard of care. We posit that this burden on the plaintiff is overbearing, and as expressed by Justice Van Rensburg, the trial judge considered and dismissed the non-negligent causes presented to him at first instance, and Ms. Armstrong had no obligation to refute all non-negligent explanations, especially when none were raised at trial by Dr. Ward. Therefore, it is not up to the trial judge to hypothesize all non-negligent causes, rather appreciate the facts presented before him and rely on the expert witnesses. The majority of the Court of Appeal concluded that the trial judge should have found that Dr. Ward met the standard of care, noting that he had not ruled out the non-negligent causes of Ms. Armstrong's injury. Making reference to paragraph 52 of our factum, you will note the majority of the Court of Appeal's position on where the burden lies with regard to ruling out non-negligent causes. We argue respectfully that the majority of the Court of Appeal placed an unfair burden on the trial judge to rule out all non-negligent causes when his or her job is to draw conclusions based on the facts and testimonies presented at trial, and as was done in the present affair. That said, the trial judge did address and reject the one potential non-negligent cause of the injury raised at the trial, and that was Dr. Ward's theory that the use of the ligature several centimeters away from the ureter was the cause of the plaintiff's damage. What the majority seem to have in their mind are other possibilities, such as the lack of dexterity on the part of the surgeon or the unexpected movement of structures during surgery. We respectfully do not accept this line of thinking and concur with the views of Justice Van Rensburg, because as seen in R.V. Cloutier, and I refer you to paragraph 54 of our factum, where it clearly is stated that a trial judge must decide a case on the evidence and only the evidence provided at trial. In addition, appellate courts have repeatedly stated that the trial judges should not rely on information obtained outside of the trial. And although a trial judge may reject the expert's opinion, he should not do so because of information that was obtained outside of trial and wasn't presented by an expert. And as mentioned by Justice Van Rensburg, it was never suggested to witnesses at the trial that non-negligent causes like the dexterity of the surgeon could lead to a surgeon using the ligature for less than 2 millimeters from less than 2 millimeters from the ureter. And contrary to what the majority discuss, these non-negligent causes are only speculative without any proof. And after analyzing the findings of expert witnesses on this issue, the trial judge accepted the opinion of Dr. Klotz and Dr. Bernstein's evidence that Dr. Ward came within 1 or 2 millimeters of the ureter, causing damage leading to scar tissue and eventually blockage in the ureter. And as a result, Ms. Armstrong's kidney had to be removed by a subsequent surgical procedure, causing significant prejudice to our client. Now, moving on to the last issue that we will be discussing, and that is the correct standard of review that ought to have been applied in the present case. And we submit respectfully that the majority erred in its application of the standard of review applicable to decisions on appeal by not applying the standard of palpable and overriding error. And the standard of review approach has been repeatedly upheld by the Supreme Court of Canada. And in a recent court decision, and I'll refer you to paragraph 57 of our factum, it identified that the standard of review is as follows. The standard of review, and I quote, is applicable to questions of law sorry, I will take it back, and I will quote, "The standard of review applicable to questions of law is correctness, while it is the standard of palpable and overriding error that applies to findings and inferences of fact," end of quote. The Supreme Court of Canada is of the view that the standard of care is a question of mixed law and fact, and it is defined in their approach in Galask v. O'Donnell, stating that, and I refer you to paragraph 58 of our factum, that the definition of the standard of care is in fact a mixed question of law and fact, and it is a trial judge that will determine what would constitute as reasonable conduct based on the reasonable man placed in the same circumstances. That said, we respectfully argue that the majority of the Court of Appeal erred in circumventing the decision of the trial judge, failing to respect principles governing standard review and especially deference to trial judges. The trial judge's decision as to the breach was supported by the evidence presented to the court, and the trial judge relied on all the evidence and expert testimony to determine the standard of care, which was to be a question of fact. In Hassan v. Anvari, and I refer you to paragraph 60 of our factum, the Court of Appeal for Ontario analyzed a similar case. In this factual frame, the appellant argued that the trial judge did not properly find the breach of standard of care by not adequately considering the other possible non-negligent causes. The Court of Appeal in this decision refused to overturn its decision since the trial judge had indeed considered the possible non-negligent causes and based on evidence had dismissed them. Like has been done in this case, the court accorded deference to the trial judge in their analysis, and citing the Housen case where the Supreme Court stated that it is not up to the appeal courts to, and I quote, "second guess the weight to be assigned to various items of evidence. If there is no palpable and overriding error with respect to the underlying facts that the trial judge relies on to draw the inference, then it is only where the inference drawing process itself is palpably in error that an appellate court can interfere with the factual conclusion," end of quote. Now, appreciating in full the Supreme Court's description of the appellate court's role, a court of appeal cannot overturn the trial decision simply because it takes a different view of the evidence. The finding of facts and the drawing of evidentiary conclusions is the province of the trial judge and was as so eloquently stated by Justice Van Rensburg. It is in Cooper v. Flood, and I refer you to paragraph 61 of our factum. You will note that the Alberta Court of Appeal dealt also with the similar case. And in this case, the appellant challenged the trial judge's decision on the grounds that he had excluded other possible non-negligent causes. And in this case, the appeals court refused to circumvent this decision, granting, again, deference to the trial judge when weighing the evidence. She explained that the trial judge's finding of negligence was not unreasonable. And in the present case, unlike the preceding two cases, the Court of Appeal did not follow the Supreme Court's decision. As mentioned by Justice Van Rensburg in her dissenting opinion, the trial judge considered all the evidence before him, and his conclusions were supported by the facts. The Court of Appeal should not have reviewed the trial judge's factual decisions since they were not palpable and overriding errors. Decisions of fact bringing together the determination of the elements of the standard of care, the determination of the cause for the purposes of the breach, and the weighing of the expert evidence. Determining whether negligence by focusing solely on the result of the medical treatment rather than the manner in which it was performed is improper and amounts to imposing a standard of excellence or perfection. However, contrary to the findings of the majority, that is not what happened here. The trial judge did not hold Dr. Ward to a standard that was higher than could be reasonably expected of an average, reasonable, prudent practitioner, performing a colectomy where no complicating features were present. And that is important to note that Ms. Armstrong, our client, is an individual that was seen by all the experts as an individual who presented a normal medical history without any complications. And as set out by the Supreme Court of Canada in Ter Newson v. Korn, the trial judge described the procedure to be followed and pointed to evidence of the need to identify the ureter and stay a safe distance away from it, and to be exact, 2 millimeters away. The trial judge's conclusions that a reasonably competent surgeon would have stayed 2 millimeters away from the ureter was fully supported by evidence. It was not a statement of result or a goal, but an essential step that was not taken by Dr. Ward. And in the Court of Appeals decision, they recognized all of the steps, except failed to recognize the final step, and that was to stay away from the ureter. Dr. Ward failed to properly execute the required step of protecting Ms. Armstrong's ureter, and the record reflects the appropriateness of the trial judge's findings which are strongly entitled to deference. The court is entitled to assume that the best evidence has been presented by the parties. Dr. Ward's decision not to lead evidence suggesting that a competent surgeon might, without negligence, come within 2 millimeters of the ureter confirms the correctness of the trial judge's decision. And for these reasons, the appellant requests this court to set aside the decision of the Court of Appeal for Ontario and restore the judgment at trial. The Court of Appeal erred in circumventing the trial judge's decision on the breach of the standard of care, exonerating Dr. Ward from tortious liability, which creates a very dangerous precedent. And the Court of Appeal erred in applying the wrong standard of review, failing to accord the deference to the trial judge on questions of fact. Thank you.
Counsel, I have a question. Sorry, just 1 second, yeah. So how do you account for the fact that Dr. Ward says he stayed 5 centimeters away from the ureter? In this case, surely it's incorrect to say that the injury suffered was only as a result of Dr. Ward, is it not?
Thank you for your question. I think there are various factors that were appreciated in the trial judge's decision in examining the facts that were before him, as well as the expert evidence that was provided by the trial judge. And it's important to note that the trial judge is best placed to make decisions on this matter. And with regard to ruling out the non-negligent causes, it's very important to note that there was a consensus within the experts that this was known as surgery 101. This is a surgical procedure that was standard for surgeons just like an appendectomy. It is a general surgery that has very low margin for error. And I'll refer you to the expert evidence that was provided by Dr. Bernstein, who noted that in his opinion, there should have not been any margin for error, and which is why the counsel for the respondent had noted or had characterized Dr. Bernstein's theory as one of zero risk. But the idea here is to note that most importantly, Dr. Ward, being an individual experienced in performing colectomies, should have been able to perform this surgery without any error. And the idea is that because of the nature of this surgery and because of the medical history that our client does demonstrate, which was one that was very normal. There were no abnormal findings in the pre-procedure. It is only fair to say that there are no other reasons, according to the trial judge, for any other reasons, in the opinion of the trial judge, that this injury could have happened, and it was thermal energy that could have been well caused by a ligature. And in the end, it's an idea. It's the idea of bringing the facts that were presented at trial. And Dr. Ward did not present any other, any causes that could have been negligent in the part of either Dr. Ward or any reasonable prudent practitioner that a reasonable prudent practitioner would have performed, or in the case of Ms. Armstrong's medical history, there was nothing to suggest that there were other negligent reasons. And as mentioned before, there's no room for the trial judge, and it is not the province of the trial judge to hypothesize any other non-negligent causes. It is his job to look at the evidence that is before him and the expert advice that is before him and draw a conclusion. And that is correctly what was done in this case.
Thank you, counsel.
Thanks for your submissions, counsel. We're talking about goals and steps. So let's say the surgeon goes in and he damages the liver instead of the ureter. Is that a goal or a step? How do we deal with that?
So the general consensus at trial with all of the experts, and according to Justice Van Rensburg's dissenting opinion, which we wholly accept, it is important to note that when a general surgeon or anyone performing a colectomy or any procedure is supposed to follow certain steps, and those steps were adopted by all of the experts at trial. And the idea is that the majority of the Court of Appeal appreciated all of the steps without noting the most important step. And it is very flawed to look at it, in our opinion, in the sense of it being a results-oriented approach, rather a step. And the most important step being staying away from the ureter because of the possible damage that could have been done to the surrounding organs, which is why in the expert evidence, the expert witnesses' testimonies, they made it very clear that, and especially in Dr. Bernstein's testimony, he made it very clear that part of the procedure is not going to step 1, 2, 3, and 4, but rather there are times throughout the procedure where step 2, step 1, step 3, step 4 have to be abided by. And in this case, making sure that there was that 2 millimeter distance was not something that had to be done once, not something that had to be twice, thrice, 100 times. It was something that had to be done as reasonably thought by the surgeon, and to ensure that they were away from all of the organs and preventing any damage that could have happened to any of the other organs. And in this case, it is our humble submission that Dr. Ward did fail to do this. And as suggested and as noted in Justice Van Rensburg's opinion, it's very clear that for a general surgeon, this is a procedure that should not have given rise to any other conflicts.
Thank you, counsel. Your time is up. The court now invites counsel for the respondents to begin.
Good morning, justices. My name is Nishani Baskarajah, and I'm here with my co-counsel today, Susie DeLuca, to represent Dr. Ward. Today, I will be making the following points on my submissions essential to this particular case. I'll start off by discussing the facts of the case and raise the error imposing standard of care on Dr. Ward. I'll first discuss my point where the standard of care is how it was met by Dr. Ward. I'll then discuss causation and how the trial judge error conflated the standard of care with causation. Upon these submissions, I will then pass it over to my co-counsel, Ms. DeLuca, who will then discuss our third and fourth submissions, which are the burden of proof on the plaintiff for non-negligent causes and standard of review is the standard of correctness. Respectfully, the trial judge erred in imposing a standard of care on the respondent, Dr. Ward, based on the absolute result of the surgery outcomes and based on the standard of perfection. All evidence suggests that Dr. Ward was complying with the standard of care and taking necessary precautions to ensure that he was several centimeters away from the ureter. On February 5th, Dr. Ward, who was a general surgeon at Royal Victoria Hospital, carried out a colectomy on Miss Armstrong. The surgery was not a straightforward procedure as it involved removing Miss Armstrong's entire colonic structure. This includes the left, right, and transverse colon. The surgery involved inserting a laparoscopic ports into the left side of the body so that the surgery can be performed on the right side, mobilizing the right colon by dividing the peritoneum and performing a dissection to push the colon into the appropriate place, including inserting the laparoscopic parts into the abdomen, and prior to mobilizing colonic structures, identifying the ureter and the blood supply movement. The Dr. Ward also had to check and keep rechecking where the ureter was when working with the tissues. Following the surgery, Ms. Armstrong attended upon Mr. Ward on three occasions between February and March 2010, with no series of concerning issues other than discomfort. Approximately 10 weeks after surgery, Ms. Armstrong reattended upon Dr. Ward, who identified an obstruction to her left ureter. Dr. Hartsburg performed a nephrectomy, which is the removal of kidney. However, Dr. Hartsburg tried to follow the ureter down and stated there was a source of scarring, and there was no mention of thermal injury. Though damages were settled in advance to the trial, the issue at trial is whether whether Dr. Ward is liable for standard of care and whether there was causation. However, in regards to standard of care, the trial judge made a series of compelling errors in deciding Dr. Ward breached the standard of care and caused the injury to Ms. Armstrong's ureter. The trial judge combined the assessment of standard of care issues with the causation analysis. This error allowed the trial judge to work backwards rather than to first define what the standard of care was to establish the breach and then determine causation of the breach. He unfortunately accepted the evidence of Ms. Armstrong that the injury that occurred would be a breach of standard care, which consequently resulted in the injury.
Counsel, I have a question.
Yes.
Isn't there some authority saying that it is permissible to assess causation first? And how do we know when it's allowed and when it's not allowed in such circumstances?
So I will be discussing causation for my next submission. And when I do discuss causation, I will be speaking about fact-specific cases in this and how medical negligence is no other than any other negligence with professional liability. There are certain standards that are to be set. And once my doctor met those standards, and when the results did occur, like the injury, there is not enough evidence to even establish causation. And I will definitely get in more deeper into that when I discuss causation.
Thanks, counsel.
Thank you. So by starting with the causation analysis, the trial judge reasoned was based on hindsight and results to impose that standard of care equated to perfection. This is an error. The correct approach to determine whether the surgeon acted reasonably in the technique employed is to identify and protect the ureter, which was not used in the assessment of breach. However, when identification and protections were considered, the trial judge was satisfied that Dr. Ward met the standard. However, because the trial judge infused the definition of standard of care with his determination regarding cause of injury, an error occurred in the finding of breach. Dr. Bernstein also agreed that this standard of care was met where Dr. Ward did identify and protect the ureter. The Court of Appeal correctly reversed this decision from the trial judge, affirming that medical negligence law must appropriately establish and define what the standard of care and then identify the breach. This was a complex surgical procedure with a known risk of ureteric injury. The trial judge solely relied on the injury itself to lead him to believe that the results of the injury was a breach of standard of care, which is improper reasoning, and this was correctly reversed by the Court of Appeal. So the standard of care has been well established for years. With respect to standard of care raised by Ms. Armstrong, this is not an issue that accurately reflects Canadian law. Standard of care is well defined and clear, and there are three essential principles for the standard of care. First, the standard of care is reasonableness in light of medical practitioners' practice guidelines. The standard of care does not equate to perfection, and the standard of care does not involve hindsight. It should be noted that the surgery completed was one that was complex, and the Honorable Court in Kritz and Sylvester affirmed that every medical practitioner must exercise a reasonable degree of care. He is bound to exercise that degree of care and skill which he would be reasonably expected of normal, prudent practitioner of the same standing and experience. Currently, the laws have adopted and affirmed the view that standard of care will be reasonably competent. Meeting that standard of care does not imply meeting perfection. In Carlson versus Sutherland, the courts overturned a trial judge's decision on the basis that imposing standard of excellence that amounted to perfection was impossible to contradict. Finally, hindsight demonstrated that assessing the standard of care in subsequent cases highlighted practitioners cannot be judged on base results rather than judge must distinguish negligence and breach of standard of care. By determining causation and reordering the negligence analysis was incorrect by law and determined that doctor was at fault for Ms. Armstrong's injury. The Court of Appeal applied this correctly and determined the trial judge made this error. Dr. Ward took reasonable steps to protect the ureter and identify the ureter as well. The next step would be to rule out any alternative factors that could have resulted in the injury for Ms. Armstrong's ureter. What factually happened was that he stayed 1 to 2 millimeters away the entire time, and he met the standard of care, and he testified this. His statements ought to be taken seriously. It is the steps, not the outcome. Elements of negligence analysis in Sanchi versus Warburg also demonstrated that standard of care must be addressed before causation. Moreover, achieving perfection for thousands of medical complex procedures is very unachievable. Professional negligence law is one that cannot be reasoned backwards from an adverse result of surgery, implying that something went wrong. By starting with the causation analysis, the trial judge's reason was based on hindsight and results to impose that the standard of care equated to perfection. I'll now move my submissions into causation, and the fact that Ms. Armstrong experienced a blocked ureter does not mean Dr. Ward's surgery was the cause of the injury, nor does it mean he was negligent. Causation being established where plaintiff proves beyond a balance of probabilities. The evidence provided by Dr. Klotz indicated that something less acute than a rupture could have occurred if the ligature was in close proximity to the ureter. Examples include necrosis or thermal injury. However, causation was not established for the procedure which contributed to the specific injury. The presence of injury does not prove causations on the balance of probabilities. And a but-for test is a general test that's used. However, it's not conclusive. This test should not be used until the breach is established, on the omission of falling short on the standard of care. Determining causation ahead of time is a critical legal error. There was substantial evidence on record to demonstrate the causation theory brought forward by my friends were not credible. Specifically, upon surgery, some expected symptoms such as leakage of urine from ureter, formation of urinoma, symptoms of progressive abdominal pain, and elevated white blood cells count, fewer in the days after surgery or possible necrosis were not present in the case. Dr. Hatzberg operative report made no mention that Ms. Armstrong's ureter had suffered a thermal injury. He had instead noted that there was scarring occurred actually quite time after the surgery. Dr. Hatzberg operative note also highlighted a significant degree of adhesions and scarring following the nephrectomy, and again, no reference to thermal injury. There is material inconsistency between Dr. Bernstein's evidence and Dr. Klotz's evidence. Dr. Bernstein testified in cross-examination that if Dr. Ward was 4 millimeters away from the ureter, as opposed to 1 to 2 millimeters, he could not have injured the ureter. No scar tissue buildup in surrounding tissues. Dr. Klotz testified that the scar tissue could have been formed in the surrounding tissue around the ureter. In Hank versus Resurface Corporation, the but-for test recognizes that compensation for negligent conduct should only be made when substantial connection between the injury and the defendant's conduct is present. It ensures that the defendant will not be held liable for plaintiff's injury where there may be other factors due to unconnected to the defendant and not at the fault of anyone. I have explained my views to why I believe the trial judge erred in the standard of care and causation analysis in imposing liability on Dr. Ward. I conclude by stating that the standard of care was met by Dr. Ward and his testimony ought to be taken into account. Additionally, causation was not established nor proved by evidence by my friends. Thank you, your justices. These are my submissions, and I will pass it over to my co-counsel to make her submissions. Thank you.
Thank you to my co-counsel, Ms. Baskarajah, for our opening remarks, and thank you, justices of the court. I have 4 main points that I would like to discuss with you today. First, my response to some of the appellant's arguments that have already been raised. Second, whether the plaintiff has a duty to rule out non-negligent causes. And we, for the respondents, would agree, yes, it is the plaintiff's duty to rule out non-negligent causes. Third, I would like to discuss whether the majority erred in applying a correctness standard of review, and if so, what is the appropriate standard of review it ought to have applied. So in this case, we agree with the majority in the Court of Appeal. It was an error in law, and for standard of care, we should be applying a standard of correctness in this review because standard of care was applied incorrectly in the trial judge's decision. And then finally, I would like to just discuss with some concluding remarks. So first, just in response to some of the appellant's arguments that were discussed today. So they had mentioned that it was a duty on the respondent's side to rule out non-negligent causes. So Dr. Ward did not breach the standard of care, so he does not need to show non-negligent causes. What we do know is that Dr. Ward took the appropriate steps as a reasonable doctor. What this comes down to is the appellant's line of argument. If they are saying that negligence was the only cause, the onus is on the plaintiff to discuss alternative reasons. And indeed, the trial judge made no factual findings of error by Dr. Ward in performing the surgery. In fact, the trial judge is quoted as saying, "I am satisfied that Dr. Ward took the steps during to identify and protect the ureter." So we're not saying that this information is coming from outside of the trial. We're using the testimony of Dr. Ward and the experts that he took the reasonable steps and stayed 5 to 15 centimeters, well beyond the 1 to 2 millimeters required for this procedure. The appellants also raised Dr. Bernstein's testimony that there shouldn't have been a margin of error. It should have been a procedure, one of zero risk to the ureter. Respectfully, for the respondents, Dr. Bernstein does not perform laparoscopic procedures. Dr. Bernstein had indicated that because there was an injury, it must have been from Dr. Ward. But what we do know from the facts, what we do know is that the trial judge indicated that Dr. Ward took the reasonable steps, and Dr. Ward testified saying that he stayed 5 to 15 centimeters away from the ureter. In response to their submissions on the standard of review, I will address this later in my remarks today. So moving on to my second point, whether the plaintiff has a duty to rule out non-negligent causes. So yes, non-negligent causes should be ruled out if their argument claims that negligence was the only cause of injury. And this was the obiter in the Court of Appeal's decision. As stated by the majority from the Court of Appeal, a trial judge who is prepared to proceed on the basis that only negligence could cause the relevant injury is obliged to consider and rule out non-negligent causes when they're defining standard of care as injury. So since they're framing the argument as negligence, it makes it the plaintiff's obligation to rule out alternative causes. The majority reasoned that more needed to be discussed in terms of accidental causes of injury, which was not addressed in the trial judge's decision. And there was an insufficiency of evidence as a result.
Counsel?
Yes.
I have a question in regards to that. Don't you think that the doctor in this case would be in a better position to raise any non-negligent causes in this case, as the patient was, presumably unconscious during the procedure and would be in a, have a more challenging time raising those non-negligent causes in this case?
Thank you for your question, Madam Justice. So Dr. Ward, what we do know is that Dr. Ward stayed 5 to 15 centimeters away. So Dr. Ward in that testimony is explaining that he met the standard of care. He took the reasonable steps as a reasonable doctor. So as such, because he took the reasonable steps, he does not need to rule out non-negligent causes because he simply was not negligent. So that's what we're saying here, is that because there was no breach and because Dr. Ward took the reasonable steps, he does not need to rule out alternatives.
Thank you.
So just continuing with my argument here, we also have the testimony from Dr. Robinette, the urologist, who testified that if the ureter was injured by thermal energy, Miss Armstrong's symptoms would have manifested much differently. So Miss Armstrong would have developed these symptoms a few days after the colectomy and not several weeks afterward. In supporting a case where only negligence could have resulted in the injury, the appellant would need to suggest that this case had exceptional circumstances. And this case was not exceptional. And even if it were exceptional, the burden would still be on the plaintiff to rule out accidental causes for injury. No evidence was provided indicating that negligence could have been the only cause, especially when the trial judge found that Dr. Ward acted reasonably. And Dr. Bernstein even agreed that Dr. Ward took the reasonable steps. In addition to this, the low risk of damaging the ureter does not mean that the actions of Dr. Ward were negligent. An error in logic would result if we inferred negligence from the low probability of injury. In addition, Dr. Ward testified that he always kept at least 5 to 15 centimeters away from the ureter. Dr. Ward followed the steps for the procedure. So I believe this to be a very important fact from the trial judge's decision that Dr. Ward stayed 5 to 15 centimeters away from the ureter at all times. And I just wanted to illustrate this with a ruler. I know that Dr. Ward did not have a ruler. But when we look at what 1 to 2 millimeters really is, it's very, very small. So you can barely see it here just from my hand where 1 to 2 millimeters is. But in contrast to that, Dr. Ward says that he stayed 5 to 15 centimeters away. That's a significant difference. So from this, we would say that Dr. Ward's actions were within the means of a reasonable doctor, and that he took the reasonable steps for this procedure, and that there is insufficient evidence that the accident that happened to Miss Armstrong was the result of negligence. Moving on to my third point, whether the majority erred in applying a correctness standard of review, and if so, what was the appropriate standard of review it ought to have applied? So we're saying that this is an error in law, which was correctly applied at the Court of Appeals decision. So we're looking for a standard of correctness. So as my co-counsel already eloquently put, when we're reviewing medical malpractice, we're in the realm of professionals, and we assess based on what a prudent doctor would do, or what a reasonable doctor would do. And this is supported in St. Jean and Mercier, where the court ruled that surgeons have an obligation of means and not the result or outcome. So we're assessing based on the steps and the means that Dr. Ward took. The trial court made an error in applying standard of care as a standard of perfection by focusing on the outcomes. The trial court took standard of care to be outcomes based. So as a result, the decision rendered in trial court conflated this causation and standard of care. So we would agree that the Court of Appeal corrected this error. So in conclusion, I'll just sum up what I've discussed with you today. So just in summary, just moving on to my main points that I discussed, whether the plaintiff has a duty to rule out non-negligent causes, yes. It is the plaintiff's duty in this case because we know that Dr. Ward took the reasonable steps. The burden rests on the plaintiff to rule out accidental causes of injury in order for their argument to hold that negligence was the only reason. And as stated by the majority from the Court of Appeal, a trial judge who is prepared to proceed on the basis that only negligence could cause the relevant injury is obliged to consider and rule out non-negligent causes. As I've already discussed, we have a very important fact from the trial judge's decision where all 4 doctors had noted that thermal spread only occurs within 1 to 2 millimeters. So that was at paragraph 37. And Dr. Ward testified that he stayed 5 to 15 centimeters away from the ureter during the operation. So that's at paragraph 54. So that's a substantial difference. And it also shows that Dr. Ward took the reasonable steps. He stayed well beyond the 1 to 2 millimeters required for this procedure. To sum up my second main point, whether the majority erred in applying a correctness standard of review, and if so, what was the appropriate standard of review it ought to have applied. So when the Court of Appeal is reviewing errors in law, the standard is correctness. The trial court made an error in applying standard of care, which the Court of Appeal corrected in this case. So instead, standard of care in the trial decision was really a standard of perfection. It was focusing on the outcomes and not the means that Dr. Ward took. So for these reasons, we for the respondent request that the Court of Appeal's decision reversing the trial decision is upheld and that these actions are dismissed. Thank you.
Thank you, counsel. The court now invites counsel for the appellant to begin their 3-minute rebuttal.
Thank you. I would like to respond to a few of the points by my friends. The first being, and we share Justice Young's concern with regards to the fact that Ms. Armstrong was under general anesthetic. We don't see how it would be reasonable to ask the plaintiff to present new non-negligent causes when she was unconscious. I also refer to my friend's arguments that the causation analysis, and in particular the but-for test, was used before establishing the standard of care. We established that that was not the case. In fact, what was happening was rather that the trial judge was attempting to determine what factually happened. And as I mentioned in my submissions earlier on, once that has been determined, once it was determined what Dr. Ward did or did not do, the outcome to the patient was irrelevant. And so the but-for test was not used. I also wanted to address the fact and essentially re-emphasize that the fact that Dr. Ward came within 2 millimeters of the ureter was a finding of fact made by the trial judge based on the evidence. And as my colleague, Mr. Kassam, mentioned in his submissions, deference is owed to that finding by the trial judge. My friends mentioned a lot of the testimony, and essentially what they're asking this court to do is to re-examine the evidence. But there was no overriding and palpable error in the trial judge's reasoning. And therefore we submit that the deference should be owed to the evidentiary and factual findings of the trial judge. I also wanted to address the comment made about the zero risk theory by that was put to the court by Dr. Bernstein. I wanted to emphasize that the trial judge himself didn't accept that theory. In his reasons, he stated that the zero risk theory was not supported by the literature. And so that theory was rejected by Justice Mulligan. And essentially, the idea behind these rebuttals is to emphasize the fact that rejecting this appeal and allowing the Court of Appeals decision to stand would set a very dangerous precedent, and in fact create a new defense, but a very dangerous precedent for medical negligence cases to come. Thank you.
This concludes the matter of Armstrong v. Ward. I just want to thank everyone for coming out and being here. You are all welcome, of course, to stay for the next session, which starts at 2 o'clock. And a huge thank you to all of our participants. You all did great. And thank you so much to all of our justices for being here as well.
Sorry, the next session starts at 1 o'clock.
Oh, sorry, I'm in a different time zone. It's at 1.
All good. Thank you.
Thank you, Bethany.
Thank you, everyone.